they will request the lawyer to be the stakeholder
Okay.
for the payments. Some, they will not even make a single cent, pay a single cent to the vendors.
So now, after taking a rest, we come to a share purchase agreement. So, Mr. Eric, what is share purchase agreement? I think you have just mentioned briefly already. Just want to ask you about share purchase agreement. Normally, when you purchase company, how is the payment being made? Okay, let's say in property purchase, it will be a progressive. This stage I pay how much, that stage I pay how much. Is there such a progressive payment term in a share purchase agreement?
Certainly. It all depends on the arrangement between the parties.
Yeah.
Some you see that 10% upon signing,
Okay.
and the remaining 90% to be paid by the purchaser
Upon
completions or closing an agreement.
I see.
But some you may also have some unique arrangement whereby maybe parties will only make the full payment upon the completion, whereby no payment is made during the signing of the share purchase agreement.
I see.
I encounter some cases are like that.
You mean to say that the money actually is being parked at the stakeholder account of a lawyer?
Or depends. Some yes, they will request the lawyer to be the stakeholder
Okay.
for the payments. Some, they will not even make a single cent, pay a single cent to the vendors.
Okay, when you mention of closing the deal, would it mean that the shares have been successfully transferred to the other
So
party?
for closing, it means that all the conditions have been fulfilled.
Okay.
And then share transfers form has been signed by both parties.
Okay.
It has been presented to the LHDM for stamping, and thereafter to be presented to SSM for the registrations.
Yes.
At the same time, the full purchase price will be paid by the purchaser to the vendors.
I'm just curious about one thing. Let's say if you were to, let's say for property purchase, I just know a bit of that. When the title is being presented with the MOT together with there's a 14A form to be submitted at the land office, presented at the land office. If a property has been transferred, there will be a land search being done to show that the property has been transferred and registered the new owner.
Yep.
Is there a search also in?
Yeah, you can do a SSM search, company search on the company to see whether the share transfer registrations has been effected or not. You can do that.
Is that record reflected? Meaning to say that I were to submit in this week, would that record of transfer be reflected within 7 days?
I think it all depends on how fast the regulators can update the records in the company.
I see.
But normally, once you submitted, there will be the evidence of submissions to be provided by the company secretaries.
I see. See, I also know that, let's say in just to do comparison, like let's say property transfer, you submit the MOT to the land office. Let's say if some any mistakes or errors in the MOT, the land office might reject the presentation. So is there also such a case in the SSM share transfers?
Yeah, because for share transfer,
you
need to execute a form called Section 105 form.
Okay.
Share transfer form. So sometimes there could be some typos on the names of the directors or the IC numbers or the parties' names or companies' numbers. So that could happen. So what you need to do is you just amend those mistakes and then you resubmit the forms.
There wouldn't be any period or say you must rectify within how many days? If not that, the transfer would be invalidated. There's no such a case, right?
I don't think so.
I see.
But of course, you want to do it as fast as possible.
But that's the job of the company secretary, not the job of the lawyer.
Yep.
Okay. It would also be like, do you think there's that you have come across any warranty in this SMP?
Oh yes, it's very common to have warranty clauses or representation clauses in the share purchase agreement.
Okay.
Like what we discussed just now, the companies or the vendors may not disclose all the documents or information to the purchaser.
Okay.
So that's where the warranties comes in, whereby in the warranty itself, we will get the vendors to warrant certain informations or certain documents or affairs of the company. If that warranty turns out to be false, misleading, not true, then the purchaser will be able to rely on those warranty clauses to claim against the vendor.
Monetary claim.
Yes, monetary claim for damages.
But can it be like, after the shares been transferred, I found out that this is not true, that is not true. Can I say that I don't want to purchase from you anymore? please give me back my money and I transfer back the shares to you. Is that possible?
Normally that will not happen.
That will not happen.
Normally that will not happen.
I see.
Because once you paid the money, I think it's very difficult for the vendors to give you back the monies. And especially when the shares has been transferred, the name has been changed. Normally the avenues for the purchaser is actually to claim for damages from the vendor.
So there's no possibility of me getting back my give back the shares to the other.
I would say it's still possible. If the vendors are willing to do so. Or if not, probably you have to get a court order to invalidate the whole thing, and then to get a specific performance from the vendor.
That's what I'm about to ask.
To transfer back the shares. So, but that would be very unlikely.
I see. Which you haven't come across.
Yeah, but possible.
I see. Yeah. This one, I think this question I will ask you about disclosure letter. I think that's about the checklist of...
Yeah. So, disclosure letter is a document to be prepared by the vendors.
Okay.
So, what they do is that sometimes they want to limit the warranties that they provided in the SPA.
Okay.
So, what they do is they will disclose everything either in the SPA itself or in a separate documents called disclosure letters. So, once they disclose, the purchaser cannot come back and say, hey, you have breached this warranty, I want to claim for you. But if the vendor has disclosed this, either in the SPA or in the form of disclosure letter, then the vendor will be safe.
I see. How is this disclosure letter being communicated? From the vendor to these purchasers or from their lawyers to your lawyers? So
normally it's done by the lawyers. So the vendor lawyers, they will go through the warranties prepared by the purchaser.
Okay.
And if the vendor feels that maybe we want to limit the warranties by disclosing certain facts in the disclosure letter, or maybe they just want to say it is to the best of their knowledge, then definitely you have to put that in the disclosure letter or in the document itself, in the SSA itself.
Do this done during the letter offer stage?
No. This is done after the signing.
Of the
after the signing or before the normally it's done before the signing. Before the signing of the SSA.
I see. The SPA.
Yeah, SPA.
Okay. So would this also be part of the SPA too?
Yes, probably yes.
That'll be the annex.
If the vendor has a lot of disclosures, that it may not be so convenient to put everything in the share purchase agreement, then definitely they will come up with another document called disclosure letter to disclose whatever matters that they want to disclose to the purchaser. This is to protect the right and also the liabilities of the vendors. It's more for the vendor disclosure letter, not so much for the purchaser. Because once they disclose that matter to the purchaser cannot come back and say, hey, I want to sue you for this breach
non-disclosure or what?
Yes, correct. Because you have disclosed.
Okay. What is the disclosure? What is the example? Or is there such an example that the disclosure clause, disclosure thing they want to disclose, look harmless but actually a bit serious from perspective of the buyer? Okay,
so definitely for disclosure letter, we want to see what are the topics that they want to disclose. Okay. So typically we want to see, especially for litigations.
Okay.
Right? When it involves the companies.
Okay.
So we want them to disclose what are the course of actions, what is the exposures of the companies. Let's say if they are being sued, so what is the maximum liabilities that the company will have to incur in case they lose the case. So with these informations, we will be able to tell the buyer that, okay, now this company is facing these suits, and these are the potential liability that the company could incur if they lose the case. You still want to go ahead or not? It's for the buyer to decide.
I see. Mr. Eric, so do you mean that if there's any litigation pending with the vendor or with the seller, you might as well ask them to show you all the cost papers?
Yeah, definitely.
Yeah.
We will get them to provide all the cost papers for the entire proceedings. Definitely we will ask. It's part of the process.
I see.
But at the same time, normally we will also request their litigation lawyer to give opinions
I see.
of the case,
I
whether it's
see.
good case, bad case, or 50-50. We will write to the lawyer in charge
Who is handling the matter?
who is handling the litigation matter, ask them to provide their own opinion.
But if they have several litigation cases pending, meaning to say that you would need to write to all the
Yes,
lawyers.
correct. We will have to write to all the lawyers that are representing the companies to
Okay.
give their opinion and also to disclose the information pertaining to the suits.
I see. Yeah, have you come across a case like when you are about to purchase the shares of the company is actually failing winding up proceedings?
So far, no. Truth. So far, not yet. But if that's the case, then probably the deal will be called off.
Oh.
Yeah.
Even though it's just in the midst of the winding up proceeding, the company is not being wound up yet.
Yeah, because when party sign the agreement, sign the SPA, there is one of the usual warranties that we will see is that the company is still a going concerns company.
I see.
And they are not facing any winding up petitions or being wound up by any creditors. So if subsequently after the signings of the SPA we discover that the target company now is being served with winding up petitions or is being wound up by the creditors, that could become a deal breaker. That could jeopardize the whole thing.
They've just been served only. When you said that after they have been served with the winding up petition, you, being a buyer, you can unilaterally terminate that agreement?
Yes. If that's provided in the warranties. Unless they disclose that, we are now facing these suits and it's up to the buyer to decide whether they still want to go ahead or not. But say if this is not disclosed before the signing of the SSA, that could potentially become a deal breaker.
Yeah, I believe you all can do the winding up search also to see that whether there's any winding up proceeding pending, right?
Yes.
Yeah, so if there's any winding up proceeding pending, can you, being a buyer, put that as a condition precedent saying that this thing must be resolved first prior to...
Yeah, that's one of the ways to overcome or to salvage the whole deal. If that's the case, normally the buyer would just want to walk away.
I see.
Because it could be too much for the buyer to deal with.
I see. Okay, so there's one more thing pertaining to the sale and purchase. After I've signed everything due diligence done, suddenly I don't want to go on with the deal anymore. I want to pull handbrake. Have you ever seen such a case?
Oh yes, for a variety of reasons.
Yeah.
Then we will see the default clauses in the share sale agreement or share purchase agreement.
Yep.
So whoever parties that defaults, definitely they have to pay a certain price such as penalties to the other parties without any good reasons.
So you see, like normal sale and purchase of the property, like that would be I pay you a 10%. If you refuse to go on with the deal, I'm entitled to forfeit the 10%.
Yep.
So is that also such a case in a sale and purchase of shares?
Yep, that's quite common in the SSA as well or SPA as well.
So that's the normal modus operandi of forfeit the 10% as well as
or more, or could be more.
Okay.
More. So it depends on the wordings or the terms in the SPA.
I see. Okay, I think that completes our session of the sale and purchase of shares. So the next session would be on the conditions precedent.